I found it inside a coffee can full of buttons. That's the part nobody believes when I tell this story, not the forged signature, not the lawyer, not the 5 years of silence. The button can. My grandmother's handwriting, folded into a business envelope, shoved under 300 mismatched buttons in a storage unit, my sister had been paying $41 a month to keep locked for half a decade. The envelope had my name on it, not the family, not whoever finds this. Mine's Dana, written in blue fountain pen, the ink a little feathered where her hand must have shaken, and it had already been opened. Someone had slit the top with a letter opener, read every word, folded it back along the same crease, and buried it under buttons in a unit my sister rented 3 towns from where either of us lived. A unit, she told me more than once, held nothing but Mom's old sewing junk, nothing you'd want. I want to tell you, I opened that letter and immediately understood everything. I didn't. I sat on an overturned plastic tote in a 10x10 storage unit in Danville, Ohio, in the middle of July, sweating through my shirt, and I just stared at my grandmother's handwriting for a long time before I could make myself read past the first line. Before I tell you what it said, and before I tell you what my sister did to make sure I never saw it, quick question, because I'm curious and it always makes these stories more fun to read back through the comments later. What time is it where you're watching this, and is anyone in your family the keeper of everything, the photos, the documents, the stuff nobody else is allowed to touch? Drop it below. I read everyone, because that was my sister, Renee. She was always the keeper. And it turns out keeper and gatekeeper are only one letter apart for a reason. My name is Dana Ellison. I'm 36. I work as a labor and delivery nurse at a hospital outside Columbus. And until 11 months ago, I believed my grandmother's estate had been settled fairly 5 years ago, exactly the way she'd wanted. I believed my older sister when she cried at the funeral. I believed her when she said Grandma Aliner left the lake cottage to her because Renee was the one who was always there. I believed a lot of things for a long time because believing them was easier than the alternative. The alternative was that my sister read a letter meant for me, understood exactly what it would cost her, and made a decision, a calm, deliberate 5 years long decision to erase it. This isn't a ghost story. Nothing supernatural happens in it. What happens is worse in a way because everything that happens to me could happen to you or to someone in your family, and there'd be no way to know until the day someone opens a coffee can full of buttons and finds out the truth was sitting 11 miles away the entire time. I should also tell you up front that this isn't a simple story about one bad sister and one wronged one, even though it might sound that way in these first few minutes. There are documents in this story, bank records, notary logs, a sworn affidavit, that make the facts about as clear as facts ever get in a family dispute. But there's also a person underneath all of it who I loved my whole life, who was scared and in over her head at exactly the wrong moment, and who made a choice she then had to keep making over and over for 5 straight years, every single time she looked at me across a holiday table and said nothing. I'm not telling you this story to make her into a cartoon. I'm telling it because I think the most honest version of what happened is also the most useful one, for anyone watching who's ever wondered what they'd do in her position, or in mine. Let me back up. You need to understand who my grandmother was before you can understand what she tried to give me, and why my sister thought it was worth burying. Aliner Voss was born in 1938 in a farmhouse outside Danville, and she died in that same county 83 years later, in March of 2021, in a hospital room that smelled like the cheap lavender lotion my mother kept insisting the nurses use on her hands. I was 29 then. Renee was 35. Grandma Aliner wasn't rich, not in the way people mean when they talk about inheritance dramas on channels like this one. She'd been a school teacher for 31 years and a widow for 19 of them, after my grandfather Walt died of a heart attack while fixing the dock at their cottage on Lake Winona. What she had when she died was the cottage itself. A 3-bedroom lake house worth around $340,000 by 2021 prices. A modest retirement account, about $22,000 in a savings account at Fifth Third Bank, and a battered green recipe box that neither Renee nor I wanted at the time, because who fights over a recipe box? She also had 2 granddaughters who could not have been more different, and she knew it better than anyone. Renee was the responsible one, or at least that was the role she'd assigned herself early and never let go of. She was the one who drove up to Danville every other weekend during Grandma's last 2 years, who managed her pill organizer, who sat through the endocrinologist appointments. I don't want to erase that. Renee really did those things, and there were years I resented that I lived 90 minutes away in Columbus with a full-time nursing schedule and a toddler and couldn't do the same. I was the one Grandma Aliner talked to about everything else. About her regrets. About Walt. About the argument she'd had with my mother, her own daughter, back in 1994 that the two of them never fully repaired before my mother passed in 2011. About how she worried specifically that Renee's husband Tom had a hole in his pocket the size of Ohio, which was Grandma's exact phrase. Because Tom had gone through 2 failed business ventures by 2019, a used car lot that folded in 18 months, and then a barbecue restaurant on Route 62 that limped along for 2 years before closing with debts I didn't know the full size of until much later. Grandma Aliner called me every Sunday night. Not Renee, me. That's not me bragging, it's just a fact that matters later because it's part of what my sister has spent 5 years trying to convince everyone, including me, wasn't true. In February of 2021, Grandma was moved into hospice care after her 3rd stroke. I took 2 weeks of unpaid leave and stayed in Danville with her, sleeping on a cot in her hospital room some nights, other nights at her cottage with Renee, who was staying there too, to be close. On March 11, 2021, Grandma Aliner asked to see a notary. I remember this specifically because I was the one who called the number. Grandma gave it to me from a business card she kept in her wallet, Gerald Prout, an estate attorney in Danville who'd handled Walt's affairs back in 2002 and had done a simple will update for Grandma a few years earlier. I dialed the office. Renee was in the room. Renee heard me make the call. 2 days later, on March 13th, someone from Prout's office came to the hospice facility. I wasn't there. I'd gone home to Columbus for 36 hours because Mark, my husband, needed help with our daughter Callie, who was 7 at the time and had a school thing I couldn't miss twice in 1 month without it becoming a conversation. Renee was there. Grandma Aliner died 4 days later on March 17, 2021 at 4:52 in the morning. Renee was in the room. I was on the highway 40 minutes out because I'd left the second I got the call and I didn't make it in time. I've spent 5 years believing that was simply bad luck. Bad timing. The kind of thing that just happens in families, no malice involved. It wasn't bad luck. It was the last piece of a plan that had already started before Grandma's heart even stopped. Before I go further, let me tell you what that cottage actually meant to me because you need to feel the shape of what was taken, not just hear the dollar figure. Lake Winona isn't a resort lake. It's small, ringed with maybe 40 cabins, the kind of place where the loudest sound most evenings is a screen door and somebody's dog barking at a heron. Grandma Aliner and Walt bought that place in 1971 for less money than a used car costs today. And every summer of my childhood, from the week school let out until Labor Day, my parents dropped Renee and me off there for stretches of 2 and 3 weeks at a time. I learned to swim off that dock. I learned to gut a bluegill at that kitchen counter, badly, with Walt laughing at me the whole time. And after he died, I learned to do it slightly less badly under Grandma Aliner's patient, unimpressed supervision. Renee has memories there too. I'm not trying to pretend she doesn't. But somewhere around the time we both hit our teenage years, Renee stopped wanting to go, preferred to stay in Columbus with friends, and I kept going every summer straight through college and into my 20s, right up until Callie was old enough to make the same trip herself. That's the why behind the letter, I think, even though Grandma never spelled it out in those exact words. It wasn't about which granddaughter loved her more. It was about which granddaughter she trusted to keep the place itself alive, the way it had always been, instead of turning it into a line item on a spreadsheet during a hard financial year. The reading of the will happened 3 weeks later in Gerald Prout's office on Main Street, a building with a bell over the door and a receptionist named Carol who'd worked there since before I was born. The will Prout read to us, Renee, me, and my mother's younger brother, Uncle Denny, who got nothing but a fishing boat and didn't seem to mind, was dated November 2018. In it, Grandma Aliner left the cottage and its contents to Renee in recognition of her caregiving. The retirement account split 50-50 between Renee and me, and the $22,000 in savings placed into a trust for my daughter Callie, accessible when Callie turned 18. I remember sitting in that office feeling 2 things at once. Grief, obviously, and something smaller and uglier underneath it that I felt guilty for even noticing, a kind of quiet ache that the cottage, the one place I actually associated with feeling safe as a kid, was going to someone who'd already told me more than once that she planned to sell it eventually once the market's better. But I didn't fight it. Renee had done the caregiving, that's what everyone kept saying. Renee earned it. And besides, the will was dated 2018, before Grandma's decline, before the strokes, before any of it. It felt clean. It felt like something Grandma had decided years in advance, with a clear head, and I told myself that clarity meant it was final in every sense of the word. What I didn't know, what I had no reason to know, was that Gerald Pruitt's office had a second document on file. Dated March 13, 2021. The day the notary visited the hospice room while I was in Columbus. I also didn't know that 4 days after the funeral, Renee drove to Pruitt's office alone and asked to see Grandma's complete file. Carol, the receptionist, let her because Renee was listed as the estate's executor and had every legal right to review it. I know this now because Carol told me, not 5 years ago. 11 months ago, when I finally started asking the right questions of the right people. And Carol, who is 71 now and in her words, done keeping other people's secrets, sat me down in her kitchen and told me everything she remembered, starting with the day my sister came in alone and left 40 minutes later holding a photocopy of something Carol never got a clear look at. At the time, back in 2021, Carol hadn't thought there was anything to notice. Executors review estate files all the time. It's routine, it's expected, and Renee was, on paper, entitled to see every page in that folder. What Carol did remember, and what she only mentioned to me because I happened to ask the right specific question, was that Renee had seemed different that day than she had at the funeral just 4 days earlier. At the funeral, Carol said Renee had been the kind of quiet, hollowed-out sad that grief actually looks like. 4 days later in the office, she'd been something closer to businesslike. Focused. Like a woman running an errand, Carol told me, not a woman still grieving her grandmother. I didn't push Carol for more than that in our first conversation. I didn't know yet how much more there was to push for. For 5 years, I didn't know any of that. I grieved. I moved on, or told myself I had. I helped Renee clean out the cottage before she eventually rented it out instead of selling it. A decision I now understand had nothing to do with sentiment and everything to do with the fact that selling it would have required an appraisal, and an appraisal might have raised questions Renee didn't want raised. I want to be honest with you about something because this story only works if I'm honest. There were small things over those 5 years that didn't sit right with me. A comment Renee made once, half joking, about how Grandma probably regretted some stuff she said toward the end. The way she flinched, just slightly, any time I brought up the notary visit. The fact that she never, not once in 5 years, wanted to talk about the last conversation she'd had with Grandma before she died. I told myself grief makes people strange. I told myself a lot of things. Then, last August, Renee and Tom's marriage finally came apart. Not because of any of this, at least not directly, but because Tom's barbecue restaurant debt had metastasized into something much bigger. Something involving a business loan he'd personally guaranteed and then defaulted on. Renee needed to downsize fast, and she needed help clearing out a storage unit in Danville she'd been paying for since 2021 and had never once mentioned to me. She asked me to help her sort through it on a Saturday in July, because Tom, in the divorce, wanted his half of whatever was in there, and Renee wanted a second set of eyes before he showed up. That's how I ended up in that storage unit. That's how I ended up holding a coffee can full of buttons that turned out to weigh a lot more than buttons should. The unit was smaller than I expected, one of those drive-up units roll door just thick enough to taste. Renee had labeled some totes in Sharpie, Kitchen, Winter COATS, Mom's Recipes. That last one made my chest tighten a little, the casual way she'd written Mom instead of Grandma, like the box belonged to some version of Grandma Aliner that had only ever existed for Renee. We worked for about 2 hours without incident. Renee was tense in a way I chalked up to the divorce, short answers, a lot of sighing, checking her phone every few minutes in case Tom showed up early. At one point, she left to move her car so a neighbor could get past us in the aisle, and that's when I opened the sewing tote by myself. It was mostly what she'd said it would be: spools of thread gone brittle with age, a pincushion shaped like a tomato, a Singer manual from maybe 1975. And underneath all of that, a red and white Folgers can, the plastic lid cracked, half full of buttons. I only opened it because I remembered, suddenly and specifically, sitting at Grandma's kitchen table as a kid sorting those exact buttons by color while she told me stories about Walt. It was a small, dumb, sentimental impulse. I wanted to hold something she'd held. I tipped the can into my palm to get a better look, and the envelope came out with the buttons, sliding free and landing face up on the concrete floor. Dana. In her handwriting, in blue ink. I didn't call out to Renee. I didn't even fully decide not to. My body just went still and quiet in that particular way it does when something matters more than you've processed yet. I sat down on an overturned tote and opened the envelope with hands that weren't quite steady. Here's roughly what it said. I'm not going to recite it word for word because some of it is still just mine, but I'll give you the shape of it because the shape of it is what changed everything. Grandma Alina wrote that she was scared and that her mind wasn't as sharp as it used to be some days, and that she wanted to put something in writing while she still could in her own hand so there'd be no confusion later. She wrote that the 2018 will didn't reflect how she actually felt anymore, that a lot had changed since then, including finding out, in early 2021, just how much debt Tom had actually taken on, debt she believed Renee didn't fully know the scope of at the time the will was writ. She wrote that she'd asked Pruitt's office to prepare an amendment, a codicil, she called it, which I had to look up later, leaving the lake cottage to me instead, because Dana is the one who will keep it a home, not sell it out from under the family the first time money gets tight, and because she wanted Callie to grow up spending summers there the way I had. She wrote that Renee would still get the retirement account in full, and the savings so that no one walked away with nothing. Grandma's word was nothing, underlined twice. And then she wrote something that made me put the letter down and just breathe for a minute before I could pick it back up. She wrote that she'd sign the codicil on March 13th in front of the notary with Pruitt's assistant as a witness, and that she was putting this letter with her buttons, the safest place I know because nobody but you would ever think to look there, as a backup, in case anything happened to the paperwork before I could see it. She was right that nobody would think to look there. She was wrong about who nobody would turn out to be because there was a signed codicil. There had been, and it hadn't been in the file Gerald Pruitt read from 3 weeks after her death. I want to tell you I confronted Renee right there in the storage unit, letter in hand, but that's not what happened. What happened is I folded the letter along its original crease, put it back in the envelope and put the envelope in my purse, and when Renee came back in from moving her car, I helped her finish sorting the unit like nothing in the world had changed. I told myself I needed time to think. Honestly, I think some part of me was protecting the version of my sister I still wanted to believe in, a version who hadn't done what the letter was starting to suggest she'd done. For about 10 days, I just sat with it. I reread the letter more times than I can count. I called Carol, the receptionist, on a whim, mostly to ask a harmless-sounding question about whether Pruitt's office still had records going back to 2021. That's when Carol, without me even pushing very hard, mentioned that Renee had come in alone 4 days after the funeral and asked to see the complete file. That's also when Carol mentioned something else, almost as an aside, that not long after that visit in April 2021, Renee had asked her, just between us, whether Pruitt still had the original signed codicil from March 13th on file, or whether Gerald had already shredded the draft since it didn't end up mattering. Carol said she'd found the question strange at the time, because as far as she knew, nothing had been shredded. Codicils don't just disappear, they get filed with the rest of the estate documents. But she hadn't thought much of it beyond that, because it wasn't her place to ask why a grieving granddaughter wanted to know about paperwork. I asked Carol as casually as I could manage with my heart going, whether Gerald Pruitt was still practicing. He was 74 years old, semi-retired, still came into the office 2 days a week. I made an appointment for the following Tuesday, telling Carol only that I wanted to review some of Grandma's old files for my own records. Before that appointment, I did confront Renee. I called her on a Thursday night after Callie was asleep, and I asked her directly, did Grandma sign anything on March 13th, the day the notary came that wasn't the 2018 will? There was a pause on the line, 3, maybe 4 seconds, which doesn't sound like much until you've lived it, before Renee said flatly, no, why would you even ask that? I told her I'd found a letter. The pause that time was longer. Then Renee said something I've replayed 100 times since, because of how careful it was, how lawyered, even though Renee has never so much as read a legal document she didn't have to. She said, "Grandma wrote a lot of things toward the end that didn't make sense, Dana. Her mind wasn't right, you know that. I'm not going to let you turn her confusion into some kind of accusation against me." I hadn't accused her of anything yet. I'd asked a question. The fact that she answered it as an accusation told me more than any document had up to that point. I didn't push further that night. I said I needed to think, and I hung up before she could say anything else, and I sat in my kitchen for a long time with the letter in front of me, feeling something shift permanently in how I understood my own sister. Mark found me there around 11, still at the table, the letter smoothed flat under my palms like I was trying to iron the truth out of it. I hadn't told him about the letter yet. I'd been carrying it alone for almost 2 weeks by then, which he pointed out gently was not exactly like me. Mark and I don't keep things from each other as a rule, and the fact that I had spoke to how much I still wanted this to somehow not be what it looked like. He read the letter twice, standing at the counter, and then he asked me the question that ended up shaping almost everything I did afterward. "What would your grandmother want you to do with this?" Not what did I want. Not what would be easiest or what would keep the peace with Renee. What would Aline Voss, a woman who'd hidden a backup letter inside a coffee can because she didn't fully trust the paperwork to survive on its own, actually want her granddaughter to do once she found it? I didn't have to think very long about the answer. She'd have wanted me to make sure it survived. That's the whole reason she wrote it in the first place. I called Andrea Fisher's office the following Monday, though it would still be another week before I actually sat down across from her, because some part of me needed to first go back to Gerald Prout myself and see, with my own eyes, whether the file really was missing what the letter said should have been in it. Gerald Prout's office hadn't changed in 5 years, same bell over the door, same smell of old paper and burnt coffee. Prout himself looked older, slower, but sharp enough when I sat across from him and told him I wanted to see Aline Voss's complete probate file. He pulled it without much hesitation. I was named in the will, which gave me a legitimate right to request records related to the estate. What was in the folder matched what I already knew. The 2018 will, the inventory of assets, the distribution records from 2021. There was no codicil. I asked him directly whether he remembered a notary visit to the hospice facility on March 13, 2021. He did remember it. He checked his old calendar, an actual paper desk calendar he still kept in a filing cabinet, and there it was. Voss Hospice Notarization LK. His assistant at the time, he told me, had been a woman named Linda Kowalski, who did double duty as the office's notary public and had since left the practice, moved to Cincinnati, as far as he knew, after resigning abruptly in the summer of 2021. I asked him what notarization meant if not the will, since the will was already dated 2018. That's when Gerald Prout got quiet in a way I recognized, because it's the same quiet doctors get when they're about to tell you something they'd rather not. He told me that he did, now that I mentioned it, vaguely recall drafting a short codicil for Aline in early 2021. A one-page amendment. Not unusual for a client who wanted to make a late change without redoing the whole will, but that he genuinely believed it had never been finalized because the signed original was never returned to the file. He said sometimes elderly clients changed their minds at the last minute or family members intervened, and a drafted document simply never got executed. He said, and I remember this exactly, I assumed it just didn't happen. I had no reason to think otherwise. I asked whether Linda Kowalski, as the notary who witnessed the March 13th signing, would have kept her own notary journal, a log of every document she notarized with dates, descriptions, and signatures, which I'd learned by then Ohio law actually requires notaries to maintain. Prout said yes. He said that journal would have gone with Linda when she left the practice, since Ohio notary journals are the personal property of the notary, not the employer. Which meant somewhere, possibly still in a box in Linda Kowalski's house in Cincinnati, there was a page with Aline Voss's name on it, dated March 13, 2021, describing a document that, according to Gerald Prout's own file, no longer existed. I left that office with 2 things, Linda Kowalski's last known city and a slow, cold certainty that my sister hadn't just found an inconvenient letter. She'd found a legally executed document and made it disappear. Real quick, if you've made it this far, I'd genuinely love to know. Do you think, at this point, you'd have confronted your sister outright or done what I did and quietly built the case first? Let me know in the comments, because I go back and forth on whether I did the right thing even now. I chose to build the case first. Partly because I'm a nurse, not a lawyer, and I knew instinctively that my sister seemed weird on the phone wasn't going to get me anywhere. And partly, if I'm honest, because some small, stubborn part of me still needed to be sure before I set fire to what was left of my relationship with the only sister I had. I hired a probate attorney named Andrea Fisher in early September, almost 2 months after the storage unit, on the recommendation of a friend from the hospital whose own family had gone through a will contest. Andrea was blunt in our first meeting, which I appreciated even though it scared me. She told me that a handwritten letter, even one clearly in a liener's handwriting, wasn't on its own enough to reopen a 5-year-old probate case. Letters express intent, she said, but intent isn't the same as an executed legal instrument. What I needed was proof that the codicil had actually existed, had actually been signed and notarized, and critically, had been deliberately withheld or destroyed rather than simply lost. She laid out in a way that honestly made my stomach drop exactly how narrow my window was. Ohio has time limits for contesting a will or reopening an estate, and mine was already tight. Courts sometimes allow exceptions for fraud discovered after the fact, but sometimes is not the same as will. She said if we were doing this, we needed to move fast and build an airtight paper trail. Because Renee's attorney, if it came to that, would absolutely argue that a 5-year gap meant I'd either known and done nothing, or that the letter itself was ambiguous, unreliable, possibly influenced by a liener's declining health in her final weeks. That last part stung, because it was almost exactly what Renee had already said to me on the phone. Andrea filed a formal request with the probate court for permission to investigate potential fraud in the original estate proceedings, which is a slower and less dramatic process than it sounds like on television, mostly paperwork, mostly waiting. While that request sat with the court, she also sent a private investigator to track down Linda Kowalski. It took him 3 weeks to find her. Linda Kowalski was living outside Cincinnati, working as a notary at a UPS store, and according to the investigator's report, visibly nervous the moment Alina Voss's name came up. She initially refused to speak with him at all. Andrea's advice was not to push Linda through intimidation, but through the law. Ohio notaries are required by statute to retain their journals, and those journals can be subpoenaed as part of a probate fraud investigation once the court authorizes discovery. In late September, the court granted Andrea's petition to open a limited investigation, based largely on Pruitt's calendar entry and his written statement confirming he recalled drafting a codicil. The subpoena for Linda Kowalski's notary journal went out on October 6th. I remember that date because it was also the day Renee called me out of nowhere, for the first time since our phone call in July, and asked, voice too casual, the way people sound when they're trying very hard not to sound anything, whether I was still stuck on that letter thing. I told her the truth. I told her I'd hired an attorney. She hung up on me. It was the first time in our lives either of us had ever hung up on the other. I sat with the phone still in my hand for a while after that, and I remember thinking with a kind of dull surprise that some part of me had still been hoping right up until that click, that she'd say something like, Dana, thank God, I've been sick about this for years, let me explain. She didn't. What I got instead was silence and then a hang-up, and it told me more clearly than any document could that whatever came next was going to be a fight, not a conversation. Andrea had warned me this might happen. In our second meeting, before the subpoena even went out, she'd walked me through what she called the 3 doors a case like mine usually goes through. Door 1, the other party, once confronted with real evidence, comes clean voluntarily, and everything gets resolved through negotiation. Door 2, they deny everything but eventually settle once the evidence becomes undeniable, usually right before or right after a court date. Door 3, they fight it all the way through a contested hearing, forcing a judge to decide, which is slower, more expensive, and harder on everyone, but sometimes unavoidable. I told Andrea I hoped for door 1. She told me kindly but honestly that in her 15 years doing this work, door 1 was the rarest of the 3 by a wide margin, because admitting fraud outright, even to family, even privately, requires a kind of honesty that people who are capable of hiding a legal document for 5 years usually aren't in the habit of offering. She turned out to be right. Renee gave me door 2 eventually, and only after there was no door 3 left to hide behind. Linda Kowalski's notary journal arrived at Andrea's office on October 29th, delivered under subpoena, along with a signed statement, Linda had reluctantly agreed to provide once her own attorney advised her that cooperating fully was a much safer position than obstructing a fraud investigation into another notary's document. The journal entry for March 13, 2021 was exactly where Gerald Pruitt's calendar said it would be. It listed Alina Voss's name, the type of document, codicil to last will and testament, the date, Alina's signature, Linda's own notary signature and seal number, and one additional detail that made the whole case click into place. A witness signature line required under Ohio law for a codicil filled in with a name I recognized instantly. Renee Ellison Hart. My sister hadn't just known the codicil existed. She had been in the room when it was signed. She had physically witnessed our grandmother sign away the cottage to me on March 13, 2021, 4 days before Grandma died, and then, 4 days after the funeral, walked into Gerald Pruitt's office alone and asked to see the file. Linda's written statement filled in what happened next in careful, lawyered language, but the substance of it was this. Sometime in the days after the funeral, Renee had contacted Linda directly, not through Pruitt's office, and asked her, as a family favor, whether the codicil could simply be treated as if it never happened, since Grandma wasn't in her right mind and it would only cause problems. Linda said she'd refuse to alter her notary journal, which is a serious crime, but admitted, and this is the part that still makes my hands shake when I read it, that she hadn't objected when Renee asked to see the physical signed document one more time, for closure, in Pruitt's office alone. With Carol's permission, 4 days after the funeral. The signed codicil never made it back into the file after that visit. Andrea's working theory, which the evidence over the following months increasingly supported, was straightforward and almost boring in its simplicity. Renee took the physical, signed, notarized codicil out of the file during that visit and destroyed it, believing that without the original document, the notary journal entry alone wouldn't be enough for anyone to ever prove it had existed. Because who, 5 years later, would ever think to track down a notary who'd left the practice, request her personal journal, and cross-reference a witness signature against a handwriting sample? Grandma Alina had planned for exactly that possibility. That's why she put the letter in the button can. She didn't fully trust the paperwork to survive on its own. She'd lived 83 years and seen enough of how families behave around money to want a backup that nobody would think to look for. She was almost right. I remember exactly where I was when Andrea called to walk me through the journal entry, sitting in the hospital break room on a 12-hour shift, half a sandwich in front of me that I never finished. She read the entry out loud, line by line, and when she got to the witness signature line, she paused and asked if I was sitting down, which is the kind of thing lawyers only say in movies until suddenly one says it to you in real life. I asked her, once I could speak again, whether a witness signature actually proved Renee had known what the document said, or whether she could claim she just signed as a formality without reading it. Andrea told me that was exactly the argument she expected Renee's side to try, if it came to that, and that it was also exactly why the timeline of Renee's own actions afterward mattered so much. A witness who signs something without reading it doesn't typically go to the attorney's office alone 4 days after the funeral to review the file. A witness who signs something without reading it doesn't ask the notary, weeks later, whether the document could be treated as if it never happened. Those weren't the actions of someone who'd been in the dark. Those were the actions of someone managing a problem she understood completely. That distinction between not knowing and choosing not to act became the spine of the entire case from that point forward. There's a second person in this story I haven't talked about much yet, and I want to be fair to him, because Andrea kept reminding me throughout this whole process that fairness matters even when, especially when you're angry. That person is Tom, Renee's now ex-husband. I don't believe Tom knew about the codicil, the letter, or any of what Renee did in April 2021. I want to be clear about that because it would be easy to paint him as a co-conspirator, and the evidence never supported that. What the evidence did support, once Andrea's investigation pulled bank and loan records as part of the broader probate fraud discovery, was a financial timeline that explained, without excusing, exactly why Renee did what she did. By March 2021, when Grandma Alina was dying, Tom's barbecue restaurant was already 6 months behind on a business loan he'd personally guaranteed. Meaning if the restaurant failed, the debt followed him and Renee personally, not just the business. The total exposure, according to the loan documents Andrea obtained, was just over $187,000. Renee, it turned out, hadn't fully known the size of that number until January 2021, 2 months before Grandma died, when the bank sent a formal notice of default to their home address. Grandma Alina knew about it too. That's part of what she referenced in the letter, the debt. She said she'd found out how bad it really was. She'd found out, I now believe, because Renee had confided in her, probably hoping for help, sometime in that same window. And instead of help, Grandma's response had been to quietly redirect the cottage to me, specifically because she didn't trust that a house left to Renee would stay in the family. She was afraid it would get pulled into Tom's debt, sold off, lost to a bank instead of kept for Callie's summers, exactly the outcome she wrote about in the letter. In other words, my grandmother's decision wasn't really about punishing Renee. It was about protecting the cottage from a financial disaster she saw coming. And Renee, I believe, understood that too, which may be part of why what she did next is so hard for me to fully condemn even while I hold her responsible for it. Because here's the layer that came out last in November when Andrea's investigator pulled property records. In July 2021, 4 months after Grandma died, 3 months after Renee made the codicil disappear, Renee took out a home equity line of credit against the cottage. $61,000 used, according to bank records, to bring the restaurant loan current and stop foreclosure proceedings on Tom's personal guarantee. She hadn't just erased my inheritance out of jealousy or spite. She'd erased it, used the house as collateral within months, and quietly kept making payments on that HELOC for years, payments that, if the codicil had been honored, she would have had no legal right to make against a house that wasn't hers. Fear, financial pressure, a husband whose failures kept landing on her. I understand the shape of what drove her. I don't think understanding it means I have to forgive what she did with it, and Andrea told me something in November I've held on to since. Motive explains a person. It doesn't excuse the choice they made once they understood exactly what that choice would cost someone else. There was one more layer to this, and it's the one that made Andrea sit up straightest when the bank records finally came through. The HELOC application itself, dated July 2021, listed Renee as the sole owner of the cottage, which was technically true under the fraudulent 2018-only version of the estate, but the application also required a notarized ownership affidavit, a separate document swearing, under penalty of perjury, that no other claims or pending amendments existed against the property. Renee signed that affidavit herself. She didn't need Linda Kowalski this time. She used a different notary at the bank branch itself, someone with no connection to Pruitt's office and no way of knowing there'd ever been a codicil at all. Which meant that by July 2021, 4 months after burying the letter's legal twin, my sister had put her signature on a sworn legal document affirming, in writing, that the very thing she knew to be false was true. Andrea explained that this affidavit, more than almost anything else in the case, was what elevated things from family estate dispute to something the court took seriously enough to refer onward. It's one thing to remove a document from a file in a moment of panic. It's another to build a second, separate sworn statement on top of that absence 4 months later, with a clear head, to unlock $61,000 against a house that wasn't legally hers to borrow against. The probate court hearing was scheduled for late January, almost 6 months after I opened that coffee can. I need to be honest about what those months were actually like, because slow burn justice is not glamorous, and I don't want to pretend it was. There were weeks where nothing happened at all, just Andrea waiting on court dates, waiting on Linda Kowalski's attorney to respond to follow-up questions, waiting on the bank to produce HELOC documents under a separate subpoena. There were nights I lay awake wondering if I was destroying my family over a house I could, in theory, have chosen to just live without. My mother was gone, so there was no one to mediate between Renee and me the way a parent might have. Uncle Denny tried once, calling me to suggest I let Renee keep the house and just take some money instead for peace. I told him peace built on a forged silence wasn't peace. He didn't call again after that, which told me where he'd landed. Callie, who was 12 by then, noticed something was wrong even though Mark and I tried to keep the worst of it away from her. She asked me once, very seriously, over dinner, why Aunt Renee doesn't come around anymore. I told her the truth in the smallest, gentlest version I could manage, that Aunt Renee and I were having a hard disagreement about something that belonged to great-grandma Alina, and that grown-ups don't always get to fix hard things quickly. Callie thought about that for a second and said, "Great-grandma would want you to fix it right, though, not just fast." I don't know where a 12-year-old gets a sentence like that, but I've thought about it more than almost anything else anyone said to me that whole year. Renee retained her own attorney in November, a man named Craig Ostrander, who, to his credit, seemed to push her toward mediation rather than a drawn-out fight, probably because the Notary Journal and the HELOC timeline together left very little room to argue the codicil hadn't existed. The mediation session in mid-December was the first time Renee and I were in the same room since the storage unit. She looked smaller than I remembered, which I know sounds dramatic, but grief and stress do visible things to a person, and Renee had been carrying both for months by then on top of the divorce. She didn't apologize outright. What she said, across a conference table with both our attorneys present, was that she'd panicked. That when she read the letter and understood what the codicil meant, she genuinely believed, or told herself she believed, that Grandma hadn't been in her right mind, and that taking the codicil out of the file was protecting Grandma's real wishes, not stealing mine. She said the HELOC had felt, at the time, like the only way to keep the restaurant loan from destroying everything, including the cottage itself, and that she'd told herself she'd figure out how to make it right eventually. 5 years is a long time to keep telling yourself eventually. I didn't yell at her in that room. I'd expected to, honestly. For months I'd rehearsed things I might say. What actually came out of me was quieter than that. I asked her whether, if I hadn't opened that coffee can, she ever would have told me. She didn't answer for a long moment, and then she said, "I don't know," which was somehow worse than if she'd just said no. I asked her one more thing before the attorneys steered us back to numbers and settlement terms, because I needed to hear the answer even if I already suspected what it would be. I asked whether she'd read the whole letter back in 2021 or just enough to understand what it meant for the house. She looked at me for a second, and something in her face went very still, and she said quietly that she'd read all of it. Every word, including the part where Grandma wrote about wanting Callie to grow up spending summers at the lake the way I had. That's the detail that still gets me, honestly, more than the money or the paperwork. Renee hadn't just hidden a document. She'd read, in our grandmother's own handwriting, a specific wish about a specific child she was fond of, her own niece, and buried it anyway under buttons for 5 years because the alternative was admitting what it would cost her. Craig, her attorney, tried to move the conversation along at that point, back towards settlement figures, and I let him, because there wasn't anywhere further that particular thread could go that would help either of us. But I remember walking out of that mediation session and sitting in my car in the parking lot for almost 20 minutes before I could make myself drive home, not crying exactly, just sitting with the strange, heavy stillness of finally having an answer to a question I'd been circling for 6 months. The court's ruling came on February 3rd, and it wasn't the clean, cinematic victory you might expect from a story like this, which I've come to think is more honest anyway. The probate judge found that the March 13th codicil had, on the balance of evidence, the Notary Journal, Pruitt's contemporaneous calendar entry, Linda Kowalski's sworn statement, and Renee's own admission during mediation, been validly executed, and that its disappearance from the estate file constituted fraud on the part of the executor. The court ordered the estate reopened and the cottage re-titled in my name, consistent with the codicil's terms. But it wasn't a clean handoff, because Renee had taken out that $61,000 HELOC against the cottage while she believed, or claimed to believe, it was legitimately hers. The debt didn't simply vanish along with her claim to the house. Andrea and Craig spent another 2 months hammering out a settlement. I would take the cottage subject to the existing HELOC balance, now down to about $48,000 after years of payments, and Renee would be required to reimburse me for that amount over 5 years, secured by a judgment the court entered against her personally. She also lost her half of the original retirement account distribution. The court found that having committed fraud, she forfeited the portion of the estate she'd have kept if she'd simply honored Grandma's actual wishes. And that amount, with interest, went into a re-established trust for Callie, closer to what our grandmother had originally intended in spirit even if not in exact structure. Renee also, separately from anything I sought, became the subject of a complaint the court referred to the county prosecutor's office, given the evidence that she'd removed a legal document from an attorney's file rather than simply lost track of it. I want to be honest that I don't know, as of the day I'm telling you this story, whether that will ever result in formal charges. Andrea told me these referrals often go nowhere, especially years after the fact, and part of me, a part I'm not entirely proud of and not entirely ashamed of either, hopes it stays that way, even after everything. That's the part of slow burn justice nobody puts in the highlight reel. There's no moment where a judge bangs a gavel and Renee gets led away in handcuffs while triumphant music plays. There's a settlement conference and a payment plan and a lot of paperwork, and a sister who I now see maybe twice a year, at Uncle Denny's 4th of July gathering and nowhere else, both of us being careful and polite in a way that used to be the opposite of how we were with each other. The judge's written order ran to 11 pages, and Andrea read most of it to me over the phone rather than making me wait for the mailed copy, because she knew how long I'd been holding my breath. What stuck with me most wasn't the ruling on the cottage itself, which I'd more or less expected by that point given everything the evidence had already shown. It was a single paragraph near the end, where the judge wrote that the court found Alina Voss's March 13th codicil to be a clear, deliberate, and competently executed expression of testamentary intent, and specifically rejected the argument, raised by Craig on Renee's behalf, that our grandmother's mental state at the time cast doubt on her wishes. The judge noted that the same notary session that produced the codicil also produced a separate, standard hospice consent form Alina had signed minutes earlier, one that required her to correctly state her full name, birth date, and the current date, which she had without error, according to Linda Kowalski's contemporaneous notes. In other words, the court didn't just rule that the document existed. It ruled that Grandma Alina knew exactly what she was doing when she signed it, which mattered to me more than almost anything else in that whole 11-page order, because it meant no one could ever again wave away her last clear wish as the confused ramblings of a dying woman. She'd been sharp, she'd been deliberate, she'd been right about needing a backup. I moved into the cottage that April, 5 years and 1 month after Grandma Alina died in that hospice room. Callie has her own room now, the one that used to be Grandma's sewing room, and yes, I kept the button can. It sits on her dresser. She doesn't know the whole story yet. She will someday when she's old enough to hold all of it the way I eventually had to. I think about my grandmother a lot in that cottage, especially in the evenings, when the light comes off the lake the exact way it did when I was a kid sorting buttons at her kitchen table. I don't think she ever wanted this. The lawsuit, the years of silence, the way her 2 granddaughters barely speak now except at family gatherings, both of us performing a kind of careful civility for everyone else's benefit. I think what she wanted, more than anything, was simply to be believed. To put something true in writing in her own hand, and trust that it would eventually reach the person it was meant for, even if she wasn't alive to make sure of it herself. She was right to not fully trust the paperwork. She was right to hide a backup somewhere nobody would think to look. What she couldn't have known, what none of us can ever really know about the people we love, is which one of her granddaughters would eventually be the one to find it, and what that person would do once she understood the weight of what she was holding. I've asked myself more times than I can count over the past year, whether I did the right thing pursuing this the way I did, all the way through a courtroom instead of quietly letting it go the way Uncle Denny wanted me to. I don't have a clean answer. I know that letting it go would have meant letting a lie stand in my grandmother's name, and I couldn't do that. I also know that pursuing it cost me the only sister I have, in every way that matters beyond a shared last name and a handful of holidays a year. Maybe both of those things can be true at once. Maybe that's just what justice actually costs. Most of the time, not villains getting what they deserve in some satisfying final scene, but 2 people who used to trust each other completely, sitting 3 seats apart at a picnic table on the 4th of July, being careful with each other for the rest of their lives. If there's a takeaway here, it's not protect your inheritance or don't trust your siblings. It's smaller than that and maybe more useful. If someone you love hands you something to keep safe, a letter, a truth, a responsibility, the safest thing you can do with it is exactly what they asked. Not what's easiest for you, not what makes your own life simpler in a hard year. What they asked. Last 4th of July, the first one after the settlement, Renee showed up to Uncle Denny's with a container of the potato salad Grandma Alina used to make, the recipe pulled straight from that battered green recipe box neither of us had wanted 5 years earlier. She didn't say anything about it. She just set it on the table between the hot dogs and the lemonade, the way Grandma always used to, and for about 4 seconds before either of us said a word to the other, it almost felt like nothing had ever happened at all. It had, though. Both of those things can sit next to each other on the same picnic table. I've learned the grief for what we lost and the small, stubborn threads that are somehow still there anyway. I don't know if Renee and I will ever get back to what we were. I've stopped expecting that, honestly, because expecting it just made the distance hurt more than it needed to. What I've settled into instead is something quieter. Two sisters who share a last name, a handful of holidays, and a story neither of us will ever tell the same way. Callie still asks, sometimes, why the buttonkin lives on her dresser instead of in a drawer somewhere out of sight. I always give her some version of the truth that fits whatever age she is that year. Someday, when she's old enough, I'll tell her all of it. The coffee can, the storage unit, the notary journal, the courtroom. I'll tell her that her great-grandmother hid a piece of the truth in the one place she was sure someone who loved her enough would eventually go looking. I just hope, when Callie hears it, the lesson she takes isn't about houses or money at all. I hope it's simpler than that. I hope it's this. Tell the people you love the truth while you still can, in your own hand if you have to, and trust that it will find its way to exactly the person who needs it, even if it takes longer than you ever wanted it to. My grandmother asked for one thing in her own hand in a coffee can full of buttons. She asked to be heard. It just took 5 years and one accidental afternoon in a storage unit for that to finally happen.